Hello everyone, welcome to ixambee's law exam channel Legal B. Today we are going to discuss the fifth legal maxim. I gave you a situation yesterday where A was a person who was accused of murder of B at Delhi, and he was saying that I was not even in Delhi. I was in Mumbai at the time of murder. So what does this situation relates to? This is usually called the plea of alibi. The term alibi means at another place or elsewhere. Matlab, at the time of that offense, the person is present at another place or he is elsewhere. This legal maxim is present under Section 11 of the Indian Evidence Act. This Section 11, is part of the chapter of relevancy of facts, where we talk about which facts are relevant in any particular case. And it reads as, when facts not otherwise relevant become relevant. Facts not otherwise relevant are relevant if they are inconsistent with any facts in issue or relevant fact. So in our example, A is saying that he was not in Delhi, he was in Mumbai. His presence in Mumbai is otherwise not relevant, but it has become relevant because it is inconsistent with any fact in issue or relevant fact. The fact in issue or relevant fact here is presence of A in Delhi, and as a result his presence in Mumbai becomes irrelevant because it is creating an inconsistency with the fact of his presence in Delhi. Another part of this section is facts not otherwise relevant become relevant if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Now let's have a look at the important case laws which are related to the plea of alibi. The first case is Lakhan Singh alias Papu versus the state of City of Delhi. Here the court stated that the plea of alibi cannot be equated with the plea of self-defense and ought to be taken at the first instance and not belatedly at the stage of defense evidence. इसका मतलब ये है कि अगर कोई प्ली ऑफ एलिबाई ऑप्ट करना चाहता है, मतलब कि वो ये बोलना चाहता है कि आई वॉज नॉट इन दिल्ली एट द टाइम ऑफ मर्डर, आई वॉज इन मुंबई, देन ही शुड नॉट वेट टिल द पॉइंट ऑफ हिज प्ली ऑफ सेल्फ डिफेंस इज प्लेस्ड. वो अपने डिफेंस में जाकर ये मत बोले, rather he should tell it at the first instance. He should not wait to tell this information with the plea of self defense. Then another important case law is Sahabuddin and another versus state of Assam. In this case law, there was a doubt in the plea of alibi. There was no substantive explanation, no substantive proof given with respect to the plea of alibi, where the person was saying that he was present at some other place. In that case, the court took a negative inference and the court did not wholly rely on the plea of alibi for the judgment. Then another important case law is Jitendra Kumar versus State of Haryana. Again, in this case, there was no sufficient supportive evidence for the plea of alibi, and thus the court did not believe the plea of alibi. The court says that if someone is raising the plea of alibi, then it should be beyond a reasonable doubt. If there is no sufficient supportive evidence, if there is no substantive explanation given with respect to the plea of alibi, then the plea of alibi cannot be relied upon. The next case is Dudnath Pandey versus State of Uttar Pradesh and State of Uttar Pradesh versus Sughar Singh. In these cases, the court said that the plea of alibi comes from the physical impossibility of the accused, but that physical impossibility should be clearly shown. What does physical impossibility here means? It means that it should be clearly shown that it was not possible for the person to travel from one place to another place and then come back to that place. If you have seen the movie Drishyam, in that movie the plea of alibi is very much used, where actor Ajay Devgan created an entire plea of alibi, an entire situation to satisfy the plea of alibi, to show that he and his family was not present at the time of murder. Now coming back to these cases, the Supreme Court said that it should be clearly shown that it was physically impossible for a person, for the accused to be present at the place of the crime. Another important case law in this is Gauri Shankar Sharma versus State of Uttar Pradesh and Sakharam versus State of Uttar Pradesh. In this case, the court said that if the plea of alibi is not established, then in that case it does not prove that the accused is guilty. Accused is still not guilty, and the burden of proof lies on the prosecution to prove the case. Just because plea of alibi established nahi ho paya, taking the same example, A is saying that I was not in Delhi, I was in Mumbai, but ये proof नहीं हो पाया, इसका मतलब ये नहीं है कि ये मान लिया जाए कि A ने ही murder किया है. There should be other evidence available. The burden of proof lies on the prosecution to prove their case, to prove the commission of offence by the accused beyond reasonable doubt. The next case is Binay Kumar Singh versus State of Bihar. In this case, the court held that alibi is not an exception which is envisaged in the Indian Penal Code or any other law. It is not an exception. It is a rule of evidence that is recognized in Section 11 of the Evidence Act, that facts which are inconsistent with the fact in issue are relevant. Thus, it should not be treated as an exception. And when it is treated as an exception under IPC, the burden of proof lies on the person who wants to prove the exception. But अगर ये exception नहीं है तो burden of proof दोनों parties पे होता है. So these are some of the important case laws that are related to the plea of alibi. Now let's take another situation. Try to guess to which legal maxim it relates to. Again we have the same person A. This person has borrowed a car from his friend, that is B. Now he is driving this car, and on the check post he is stopped by the police to check the contents of the car. In the back trunk of the car, certain material, certain articles are found. A says that I was not aware of the presence of these articles. Then will A be liable for carrying such articles, for carrying such material? This is my first question. And while driving this car, A crosses a red light. A jumps a red light and is stopped by the police person. Now in that case, is A liable? Can A be excused from the offence in both these circumstances or in either of these circumstances? And to which legal maxim these two situations relate to? At ixambee, we have online courses for preparation for various law exams. ixambee is your one-stop solution for all legal exams preparation. We have banking law officer exam courses, insurance law officer exam courses, Coal India legal officer, banking law officer for scale 2, regulatory body law officer exam courses. If you are interested in any of the course, you want to prepare for any of these exams, you can check out the demo of these courses present in the description below. For any of your queries, you can write in the comment box. You can also write to us at hello@ixambee.com or call us on the number mentioned on the screen. Subscribe to our Legal Bee channel to stay updated with such relevant content, with information relating to law exam notifications, preparation guidance, study plans, and a lot of other relevant content. Thank you.